Good afternoon, everyone. This is the case of the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with Ms. Nelson and Ms. Spengler, and the people are represented by Mr. Orman, Ms. Pearson, Ms. Stitch McGuire, and Mr. Edson. And we are outside the presence of the jury to talk about instructions. The record should reflect that we previously had a jury instructions conference, and so this is really the second formal jury instructions conference that we have in the case. Before we start, I want to make a record about a couple of things related to instructions. The first one is I want to confirm that the defense is asking the court to instruct the jury on some lesser included offenses. And my understanding, Ms. Nelson, and please correct me if I'm wrong, is that with respect to the counts of first degree, murder in the first degree after deliberation and murder in the first degree extreme indifference, you're asking the court to instruct the jury on the lesser included offenses of murder in the second degree and manslaughter. And is that correct?
That's correct.
All right. And with respect to the charges of attempt to commit murder in the first degree after deliberation and attempt to commit murder in the first degree extreme indifference, you're asking the court to instruct the jury on the lesser included offenses of attempt to commit second degree murder and attempt to commit manslaughter. Is that correct?
Also correct.
Okay. And I want to make sure that although the people object to the court instructing the jury on these lesser included offenses that I just mentioned, there's no dispute here that murder in the second degree and manslaughter are lesser included offenses of murder in the first degree after deliberation and murder in the first degree extreme indifference. The people agree with that, right?
Yes, Your Honor, we do agree with that.
Okay. And you agree with that as well, right, Ms. Nelson?
Yes, Your Honor.
Okay, there's also no dispute with respect to attempt to commit murder in the second degree and attempt to commit manslaughter being lesser included offenses of attempt to commit murder in the first degree after deliberation and attempt to commit murder in the first degree extreme indifference. Is that right?
They are, Your Honor.
Okay, and you agree?
Agreed.
Okay. And the final thing is, I wanted to make sure we're all on the same page with respect to insanity being a defense to all the charges in this case, all 165 charges, as well as all of the lesser included offenses that have been requested by the defense, which the court is instructing the jury on. Do the people agree with that?
Yes, Your Honor, unless the defendant wants to make it for less than all the charges, but I think it is for all the charges.
All right, and Ms. Nelson, you agree with that?
Yes, Your Honor.
Okay, great. With that record then, let me make a record next about the request for lesser included offenses. The prosecution objected to the defendant's request for the lesser included offenses that I mentioned a moment ago. And under Apodaca versus People, that's APODACA 712 Pacific 2nd 467, Colorado Supreme Court case from 1985, a defendant is entitled to an instruction on a lesser included offense only if there's a rational basis for a verdict acquitting the defendant of the offense charged and convicting him of the included offense, where the evidence is such that the defendant must either be guilty of the greater offense or not guilty of any criminal conduct at all. An instruction on a lesser included offense is inappropriate. And I'm also looking at section 18-1-408 subsection 6, which Apodaca relied on. That statute or that subsection states as follows. The court shall not be obligated to charge the jury with respect to an included offense unless there is a rational basis for a verdict acquitting the defendant of the offense charged and convicting him of the included offense. And I found Ms. Nelson's argument in support of her request for the lesser included offenses mentioned persuasive. What she said is, it's possible and plausible, based on the evidence presented, that the jury here would find the defendant not guilty of the charged offenses based on the insanity defense, but then would find that he's guilty of a lesser included offense, such as second-degree murder, for example, or manslaughter. And it's given that part of the definition of insanity has to do with capacity to form the culpable mental state. I think there's a rational basis for the jury to conclude that the defendant had the capacity to form the culpable mental state for acting after deliberation and with intent with respect to the first-degree murder charges, but then concluding that he might be, that the defendant did not have the capacity to form the culpable mental state of intent after deliberation, but he had the capacity to form the culpable mental state, for example, of reckless, or for example, of knowingly with respect to certain types of first-degree murder charges. So I felt that it was appropriate to instruct on the lesser included offenses that were requested. I know that people objected, Mr. Orman, and I'm overruling the objection. Is there any other record that you want to make with respect to that? And Mr. Orman, I think in all fairness, my recollection is that you thought that at least with respect to the reckless lesser included offenses, it was I thought you said it was a close call, but with respect to the other ones, it was not. And maybe I'm getting those mixed up. I know that you said at least one of the lessers, you thought it was a close call.
It was a while ago, Your Honor. I don't exactly remember what our conversation was, but the one comment I would make is, and I understand the court's ruling, that for the charge of extreme indifference murder, both the charges where people were killed and the attempted murder charges, the culpable mental state portion of the offense of murder in the first degree and murder in the second degree, or attempted for those charges, is both knowingly. The difference is for the second degree murder would not require circumstances manifesting an extreme indifference to human life in general. I don't know that the circumstances evidencing, well, you know what I'm saying, is part of a culpable mental state. I think it's probably a separate element. So I'm not sure that the rationale of they could find him guilty of a lesser offense because they felt that the insanity evidence negated the culpable mental state of knowingly would apply to those charges. But that's all I have to say at this point, unless Your Honor wants to hear more from me.
No, and I had the same thought that you had, and I that was the one that caused me more concern because it's the same mental state. It's the mental state of knowingly, but it's one of them requires knowingly with respect to acting knowingly or having the capacity to act knowingly with respect to certain circumstances and results, and the other one, it's with respect to other circumstances and results. Frankly, I don't know whether that would make a difference, but, and I couldn't find any case law on point that would answer that question, and I felt that it would be better to err on the side of instructing on it than not. In terms of the reckless, it's a completely different mental state, and it's, I think, entirely plausible that, and I think there would be a rational basis for a verdict that would acquit the defendant of the offenses charged, but would find him guilty of a lesser included offense that has a culpable mental state of reckless. It's possible that the jury would say the insanity defense prevents a verdict of guilty on say a charged offense of first-degree murder because the defendant did not have the capacity to act with intent and after deliberation, or perhaps even to act knowingly, but that the defendant had the capacity to act recklessly. That to me, the evidence here allows for a rational basis for that type of result. And so I think definitely the manslaughter, I think, is the more difficult argument for the prosecution. And perhaps that's what you were saying last time, and I don't want to misconstrue what you said. And whatever you said, there's a record of it. But my recollection is that I think you had a tougher time objecting to the request for a lesser included offense of manslaughter as opposed to the second-degree murder. Similarly, you had a tougher time, I think, objecting to the request for the lesser included offense of attempted manslaughter as opposed to the request for a lesser included offense of attempted second-degree murder.
Ask for one clarification for
Yes.
the record, Your Honor. I just think this is important because I know many victims may be watching this trial either here or elsewhere because of it being on TV. And I understood the court's remarks, and I know all the attorneys who are experienced trial attorneys understood the court's remarks, to be discussing the plausibility and the rational basis in terms of a hypothetical person looking at the evidence, and that the court was in no way commenting on the court's opinions about the evidence, and that is not what you were doing. And every lawyer in here understood that. But I just want to make it clear, I think we all know that the court was not in any way commenting on its thoughts of the evidence or the charges in this case.
Absolutely. Yeah, absolutely. And this is the discussion we have to have with respect to the lesser included offenses, as you know. I mean, this is what the law requires, and this is what a court has to do. The court has to look at the evidence, and the court has to determine whether there is a rational basis for a verdict acquitting the defendant of the offense charged, but convicting him of a lesser offense. That doesn't mean that I have an opinion on the evidence. I'm neutral in these proceedings, as I have been repeating throughout. That doesn't mean that I believe that the jury is going to acquit or not acquit of any charge offense. I'm just making a finding based on what the law is that I'm required to make. And that is that I have to look at the evidence and decide, is it possible, is it rational that it would be possible that the jury could look at this and say, well, we find the insanity defense convincing with respect to the charge offense of first-degree murder, but that the jury could also say, but we think the defendant would have had the culpable mental state to act recklessly, although not after deliberation and with intent. So, Ms. Nelson, any other record that you want to make or anything you want to say in response to the dialogue that I've been having so far with Mr. Orman?
I do have some additional argument to make about the specific language in the lesser included instructions that the court has generated.
Right.
But I don't know if you want to wait until if we're going to go through each instruction one by one.
Yes.
Okay.
We
Then I can do
will. I
that.
just was asking in general about the concepts. I couldn't find any case law on point on the issue that was raised by Mr. Orman, which is that if the defendant has the capacity to act knowingly under the first-degree murder extreme indifference charge, then doesn't that also mean that he necessarily had the capacity to act knowingly with respect to the first-degree murder charge of, or with respect to the lesser included of second-degree murder? And in that case, should I be giving the jury that lesser included offense of second-degree murder?
I don't think I need to wade into that area if the court is giving the instructions that we've requested.
Okay. Like I said, Mr. Orman, I thought about that. I couldn't find any authority on point, and I just felt like it was the more appropriate course of action was to err on the side of caution. But that is a thought process I had as well. And so, all right, let's get to the instructions, and then if we can go each instruction one by one, please. Before we start, let me tell you about two things that I noticed. One is, and for the record, we're looking at the last draft set of the instructions that I gave the parties. I think it was on July 2nd, so about a week ago, and they're posted, and so they're not posted on the public website, but they're in the file. They've been filed. So I'm looking at the instruction that starts with in this case, a separate offense is charged against the defendant in each count. Each count charges a separate and distinct offense, and the evidence and the law applicable to each count should be considered separately. That instruction, that sentence that I was just reading, and I'll read it in full. Each count charges a separate and distinct offense, and the evidence and the law applicable to each count should be considered separately and influenced by your decision as to any other count. I wondered if it made sense to have a comma after the word offense, distinct, after the term distinct offense, and before, and the evidence and the law applicable to each count. Does either party have a position on that?
Makes sense to me, Your Honor.
Any objection, Ms. Nelson?
No objection.
All right, I'll do that. Give me just a sec. And the other thing I had was, after looking at the instructions again earlier today, or browsing through them earlier today, it occurred to me that it might make more sense to put the culpable mental state element instruction after the elemental instructions, because the jury hasn't heard much, if anything, about the recklessly culpable mental state. And if they read that first, I wonder if they might be confused by that. Whereas if we put it after all the elemental instructions, then they will have heard the word recklessly when I talk about the lesser included offenses of each type of charged offense. Do the parties have a position on that?
We're okay with that, Your Honor.
All right, are you okay with that as well, Ms. Nelson? Yes, sir. Okay, I'll do it that way. All right, and Mr. Orman, I just had a thought. Something just occurred to me in terms of the discussion we were having. I'm going to look at one other source and do some more research. If I happen to change my mind on the lesser included offense of second-degree murder, I'll let you folks know. But at this point, based on what the research I've done, I didn't find anything on point. But I just thought of another source that I need to look at, and so I would email you folks through my staff if that comes up.
I would request an opportunity to make an additional argument if the court does consider changing its mind.
Absolutely. All right, let's go through the instructions. The first instruction is the members of the jury instruction. Any objections or suggestions from the people?
No, Your Honor, we're fine with this.
Ms. Nelson?
I do have one, Your Honor, and I noticed that when the court gave this instruction to the jury today, it actually did modify it. Just on the second page, in the first paragraph where it states, all you can tell family members, friends, acquaintances, and strangers is that you are on a jury in Arapahoe County that is anticipated to be completed by the end of August, especially because this instruction is going to be given to the jury in mid-July, right before they are deliberating. I think it's appropriate for it to say at the latest by the end of August, or by the end of August at the latest.
Okay, I will change that. Any objection?
I think it's a distinction without a difference, Your Honor.
I disagree, Your Honor. I think that it implies that this case is necessarily going to go to a penalty phase if you keep that language in there stating that the case is not going to be completed until the end of August.
I will change it. So it'll read at the latest at the end of August, okay?
I think that this is all part of one instruction. I have one more thing on this
Yes.
one. On the last page, second to last paragraph, it states, I have asked questions of witnesses during the trial. That did not mean I had any opinion about the facts in the case. I could be wrong, but I don't remember the court asking any substantive questions of any witnesses in the case, aside from reading the questions that jurors have submitted, which the jurors obviously know are their own questions that the court's just reading. And so I wasn't sure if we needed that in there, or if it was confusing to the jury in any way.
I think I did ask a couple of clarifying questions, of witnesses during the trial. When they said something and I either didn't hear it, or perhaps I wanted them to clarify the date or the year or something along those lines. So that's my recollection.
My recollection was, I think a couple times a witness might have said like 2014 when they meant 2012, or something like that, and you said, did you mean 2012?
Right. Okay.
I just wanted to point that out.
Okay, thank you. All right, let's go on to the next one then. The second instruction, this is the charges against the defendant are not evidence, or it starts with that. And just so that it's clear, Ms. Nelson, are you asking to incorporate by reference the record that you made before so you don't have to repeat it again?
Indeed, Your Honor, I was going to say that for each of these. But yes, I do incorporate by reference all of the arguments that I made at the previous charging conference in June.
Okay. And same thing for the people, right?
I don't remember making any objections, but to the extent we did, yes, Your Honor.
Okay, great. All right, anything additional then with respect to this instruction at this time from the people?
No, Your Honor.
From the defense?
Nothing additional to what I argued previously.
Okay, the next instruction is the stock presumption of innocence, reasonable doubt, burden of proof. Actually, the order is presumption of innocence, burden of proof, reasonable doubt. Anything from the people on this one, Mr. Orman?
No, Your Honor.
Anything from the defense on this one?
Nothing additional.
All right, the next one is the number of witnesses testifying for or against a certain fact. Anything additional from the people?
No, Your Honor.
Anything additional from the defense?
No, Your Honor.
The next one is the credibility instruction. Again, it's the stock instruction in the model jury instructions. Anything from the people?
No, Your Honor.
Anything additional from the defense?
No, Your Honor.
The next one is expert testimony. Anything additional from the people?
No, Your Honor. Thank you.
Anything additional from the defense?
No, Your Honor.
The next one is the definition of direct and circumstantial evidence. Anything from the people on this one?
No, Your Honor.
Anything additional from you, Ms. Nelson?
No, Your Honor.
Next, we have the limited purpose instruction. Anything on behalf of the people on this one?
No, Your Honor, can I make a request?
Yes.
Since we're going through these really fast, and I feel sort of like a yo-yo, would it be possible for me to answer your questions sitting down for this purpose?
Yes.
Okay.
That's
thank
fine.
May I make the same request?
Well, I don't know. Is it going to make you feel like a yo-yo if you don't stay seated? Yes.
I
of
incorporate by reference Mr. Orman's arguments.
course. Okay. I don't want anybody to feel like a yo-yo. Okay. All right. So, Mr. Orman, now that you're sitting down, anything additional with respect to this one?
No, Your Honor. Miss Pearson tells me it was more like a jack-in-the-box.
Jack in the box, yes. You sounded much more comfortable now, so I'm glad you're sitting down. All right. Ms. Nelson, what about you? Anything additional from you on this one?
I'm sorry, are we talking about the right not to testify or the limited
purpose.
purpose? No, nothing additional.
Next one is the right not to testify instruction. Anything additional from the people?
No, Your Honor. Thank you.
Anything additional from you, Ms. Nelson?
Nothing additional.
Okay. The next one is, in this case, a separate offense is charged against the defendant in each count. Anything additional from the people?
No, Your Honor.
Anything additional from the defense?
No.
And you'll see, Ms. Nelson, that this one reflects that the prosecution, that it says that the fact that the jury may find the defendant guilty, not guilty, or not guilty by reason of insanity of one of the charged offenses should not control its verdict as to any other charged offense against the defendant. It also says that the defendant may be found guilty, not guilty, or not guilty by reason of insanity of any one or all of the charged offenses. And that was important based on the case law that I cited to you last week when I gave you this set of instructions. I think it was Collins, People versus Collins, a Colorado Supreme Court case. It was, and the other one is Bielecki, People versus Bielecki, Bielecki. Collins is cited at 752 Pacific 2nd 93. Bielecki is cited at 964 Pacific 2nd at 598. And I don't know if that, I think it's 598 where it starts. And then also it's based on the statute that I cited last week, 16-8-105.5 subsection 3.
And Your Honor, I do have some arguments I'd like to make about the verdict forms. I'll wait till we get there, but I
Okay.
don't have an objection to this instruction in and of itself.
Okay, great. For now, the next one in my stack is the culpable mental state instruction, although I'm going to move it to after all the elemental instructions and right before the insanity defense instruction. But since it's in this order right now, and I think this is the draft that's on file, let's just talk about it now. Anything additional with respect to this instruction from the people?
Yes, Your Honor. The issue I see with this instruction, which I believe is taken from the new model jury instructions that the Supreme Court has promulgated, is that it uses the phrase culpable state of mind instead of culpable mental state. The insanity instruction uses the term culpable mental state. And I think that for consistency, they should be the same, because it may be confusing to jurors when we say culpable mental state, and they look and they say, then I could see a question from a juror coming back to the court. Is that the same thing? So I think we should just change this to culpable mental state.
And that would mean changing it throughout then?
Yeah, I think this is the only instruction that has that phrase in it, but throughout this instruction, yes.
Right. Okay. Ms. Nelson, any objection?
No.
All right. I agree with that suggestion, so I'll make that change. Give me a second. Anything else from you, Ms. Nelson, with respect to this instruction?
No, Your Honor.
All right, next we have the definitional instruction. Anything additional from the people?
No, Your Honor, thank you.
Anything additional from the defense?
Excuse me, Your Honor. I do have some issues with the part of the instruction that discusses the verdict form, but because it's all connected to my general objections and issues with the verdict form, perhaps it would make sense to just wait and talk about the verdict form when we get to the end of these instructions and make one comprehensive argument about it.
Oh, where it says verdict questions?
It explains just the discussion of Part A of the verdict form and how the jury should go about filling out the verdict form.
Wait, I think you may be looking at the wrong one. I'm looking at the definitional instruction that says, in this case, certain words and phrases have particular meanings.
Oh, no, nothing. No, I'm sorry. I got ahead of you. No, nothing on that.
Okay, so you're okay with that one, right? Okay. All right, let's go to the elemental instructions now. The first elemental instruction is related to the charge or the charges of murder in the first degree after deliberation, and it applies to counts 1 through 12. Is there anything additional on behalf of the people with respect to this instruction?
No, Your Honor.
Anything additional from the defense with respect to this instruction?
This is the instruction I was referring to a moment ago. I do have some things to say about the verdict forms, and then that in turn relates to the last part of this instruction, telling the jury how to complete the verdict form. So I think it probably makes sense to talk about the verdict forms when we get there, and just make an argument about how the instructions relate to the verdict form when I make my argument about the verdict forms themselves, if that's okay with the court.
That's okay with me, as long as you remind me to come back to this if we change anything in the verdict forms.
Okay.
Okay? All right, the next one is the lesser included offenses with respect to the charges of murder in the first degree after deliberation. And Mr. Orman, other than the fact that you object to the lesser included offense of second degree murder, anything additional with respect to this instruction?
No, Your Honor.
All right, Ms. Nelson, anything additional from you with respect to this instruction?
Yes, Your Honor, this is the lesser included instruction. I'm
Yes.
sorry, I got a little bit out of order again. Yes, yes.
This is the lesser included instruction with respect to the charges of murder in the first degree after deliberation, and it includes the lesser included offenses of murder in the second degree and manslaughter.
Yes, Your Honor. We object to the first paragraph. I understand that it's taken from the model instructions. I understand what the court's position is probably going to be. Nevertheless, I'd like to make a record that we do object to the language in that first paragraph. If you are not satisfied beyond a reasonable doubt that the defendant is guilty of the charged offense in account listed in instruction, etc., because it doesn't convey to the jury clearly enough what Colorado law is, which is that the jury need not acquit a defendant of a greater offense in order to consider a lesser included offense. And it was for that reason that we proposed the language that we submitted with our proposed instructions on the lesser included offenses. And I'm referring specifically to the first and second paragraphs of those instructions, which read, our proposal would be to simply state the offense of first-degree murder after deliberation necessarily includes the lesser offenses of second-degree murder and reckless manslaughter, and then an additional paragraph stating you do not need to unanimously agree that Mr. Holmes is not guilty of a greater charge in order to consider whether he is guilty of a lesser offense. The law does not restrict the order in which you may consider the various offenses. And we base our argument on the case law cited in our proposed instructions, and also on Mr. Holmes's constitutional rights to present a defense, to due process, to a fair and impartial jury, as well as the heightened reliability that's required by the Eighth Amendment and Article 2, Section 20 of the Colorado Constitution, because this is a case in which the death penalty is being sought. And I would specifically cite to Beck versus Alabama, which is a case that we've cited throughout these proceedings, because the concern is that the instructions as they are written may increase the risk of an unwarranted conviction unless it's clearly explained to the jury that they need not acquit Mr. Holmes of the greater offense in order to consider the lesser included.
Okay, Mr. Orman, any response?
The law of Colorado, Your Honor. It used to be. It used to be actually if a jury came back and they said they were hung, and the court could send back a instruction saying, hey, is it just about the degree of the offense or guilt or not guilty? And if it was about the degree of the offense, the jury could come back and you could instruct the jury to say, hey, just give us a verdict on what you can all agree on, the highest charge. And judges used to do that, and the legislature passed a statute, and it didn't occur to me to look it up until right now, and I haven't had a chance to do that, but there's actually a specific statute now that says you can't do that. So it's just not the law. They do actually have to acquit on the higher charge before they can get to the lower one, and if they're hung on that, they're hung.
All right, I am confident that this is an accurate statement of the law, and it is consistent with the model instructions, and so I'm going to stick with it. So the objection is overruled. Let's go to the next instruction, and the defense's standard instruction, I should say, remains rejected. The next instruction is the elemental instruction for murder in the first degree extreme indifference. Mr. Orman, is there anything additional from the people with respect to this one, which, by the way, applies to counts 13 through 24?
No, Your Honor.
Anything additional from you with respect to this instruction, Ms. Nelson?
Same issue, and I should have made that record with the last instruction on the lesser included offense as well. For all of these instructions, because of our issues with the verdict forms, I do have some argument to make about or some objections about the description of how to fill out the verdict form, but I'll reserve argument about that until we get to the verdict form itself.
Okay. All right. Next, I have the lesser included offenses instruction with respect to murder in the first degree extreme indifference. Mr. Orman, other than the fact that you object to the lesser included offense of murder in the second degree, is there anything else with respect to this one?
No, Your Honor.
Anything in addition for you, Ms. Nelson, other than the same record that you made with respect to the last lesser included offense instruction?
Same record.
Same record? Okay, thank you. Next, we have the elemental instruction for attempt to commit murder in the first degree after deliberation, which applies to the counts that are listed in this instruction. Anything additional for you, Mr. Orman?
No, Your Honor, thank you.
Ms. Nelson, anything additional for you other than the record that you made before with respect to the references to Part A of the verdict form?
Nothing additional to that.
Okay. Next, we have the lesser included offenses instruction for the attempt to commit murder in the first degree after deliberation charges, and it includes attempt to commit murder in the second degree and attempt to commit manslaughter. Mr. Orman, other than the fact that you object to the lesser included offense of attempt to commit murder in the second degree, any objection with respect to this one?
No, Your Honor.
And Ms. Nelson, anything in addition from you, other than the record that you've made with respect to the previous lesser included offenses instructions that we've talked about?
Same record.
Same record, okay. Next, we have the elemental instruction for attempt to commit murder in the first degree extreme indifference and all the counts that it applies to which are listed in the instruction. Anything additional from the people with respect to this instruction?
No, Your Honor.
Ms. Nelson, anything in addition to the record that you've made already with respect to the references to Part A of the verdict form?
Nothing additional.
All right. Next, we have the lesser included offenses with respect to attempt to commit murder in the first degree extreme indifference. Mr. Orman, other than the fact that you object to the lesser included offense of attempt to commit murder in the second degree, anything additional with respect to this instruction?
Nothing, Your Honor. Thank you.
Ms. Nelson, any other record that you want to make with respect to this instruction that is in addition to the record you've made with respect to the three prior lesser included offenses instructions that we've talked about?
Same record. Thank you, Your Honor.
Next, we have the elemental instruction for possession or control of an explosive or incendiary device. Mr. Orman, anything with respect to this instruction from the people?
It's not an objection, Your Honor. It's just something I noticed looking at this, is that the charge is titled possession or control, which I think is correct, but the element number 4 talks about more than possession or control. I don't know if that's confusing, but I don't know of a way to fix that.
I think that's the formal title that I saw in the model instruction. That's also the formal title in the complaint and information that was filed by the people. I noticed that too, and I'm not sure we want to call it possession or control or manufacture or giving or mailing or sending or causing.
Obviously, only the first 3 apply, but we need to give the instruction as far as the 6 elements as they are. But I'm not saying we need to change it. It's just something I noticed that I thought I'd bring to the attention of the court.
Well, if you both agree, what we could do is we could change the title to possession, control, or manufacture of an explosive or incendiary device, and then we could change element 4 by leaving only the relevant portion, which is possessed, control, or manufactured, and then getting rid of the stuff that doesn't apply.
If the defense does not object, that is my preference.
All right, Ms. Nelson, how would you like to proceed?
I would like to keep it as it's written.
Okay, then we'll keep it as it's written. Anything additional then from you, Mr. Orman, with respect to this instruction?
No, Your Honor, thank you.
All right, Ms. Nelson, anything in additional from you with respect to this instruction?
Just the same record about the reference to Part A of the verdict form.
All right, and the title doesn't bother you. In other words, the concern that was raised by Mr. Orman, you want to keep it the way it is, right? You would rather not change it as I proposed or to change it in a different way. Is that correct?
I think that's correct, Your Honor. I think that's the way that the model instruction has it laid out, and I think it's appropriate to keep it that way in this circumstance.
Okay, we'll keep it that way. Next would be the culpable mental state instructions, but we've talked about that one already, so we'll go to the one that's next now, and that is the defense of insanity instruction. Mr. Orman, and before I go to Mr. Orman, you folks may have noticed that, and for the record, I have deviated from the instructions from the model instructions for a couple of reasons. Maybe it's 3 reasons. Number 1, we have numerous counts in this case, and so it becomes a challenge to speak in the singular, and I think it risks confusing the jury if I leave the instructions in the singular. And this is one in particular that I felt like we needed to be careful in how we worded the explanation to the jury so that the jury would understand that it applies to each act. So I've done my best to do that. And in this case, there is more than one alleged act, and so I think it's important to do that. That's one thing. Secondly, there are lesser included offenses in this case. And so that's another circumstance that I think warrants and perhaps requires the court deviating to some extent from the model instruction. And this is not the only model instruction that I deviated from, but when I got to this one, it reminded me that I wanted to make a record about this. The fact that I'm using or giving some lesser included offenses, or I'm instructing the jury on some lesser included offenses, requires me, frankly, to change some of the language in the instructions to account for the lesser included offenses and to avoid confusion of the issues. And so that was a second reason for doing that. So those are the reasons that I think those are the reasons that led me to change some of the language in the model instruction. To the extent that I could, I tried to stay true to the model instructions wherever possible. And even where I changed language, I still tried to follow the structure in the model instructions because it was important to me to do that. That's always the safest route to go. I know that they're only a guide, but I think it's always dangerous to deviate from them. In this case, there were certain instances where I had little choice but to do that in order to avoid confusing the jury or misleading the jury. So, having said that, with respect to this instruction on insanity, and that's the other reason why I had to change some of the language in the instructions was that we have the defense of insanity in this case. Now, that doesn't apply to this particular instruction because this is the instruction on insanity, but it may apply to other instructions. And so at times I deviated from the model instructions based on that. Now, Mr. Orman, having made that record, anything with respect to this instruction from the people?
No, Your Honor, thank you.
All right, anything from the defense with respect to this instruction, Ms. Nelson?
I incorporate and maintain all of my previous objections and proposed revisions that we discussed at the last conference. I have one other thing, Your Honor, on the second page of the instruction with the paragraph that starts with the prosecution has the burden to prove beyond a reasonable doubt.
Yes.
It just struck me as it seemed a little bit repetitive and confusing. The sentence that states, in other words, the prosecution must disprove beyond a reasonable doubt both of the above numbered conditions with respect to the act alleged in the charged offense in each count and in each of the lesser included offenses of that charged offense. That's seems to be almost entirely repetitive of the sentence just before that. And so I just wanted to propose amending it to state simply, in order to meet this burden of proof, the prosecution must disprove beyond a reasonable doubt both of the above numbered conditions with respect to the act alleged in the charged offense in each count and in each of the lesser included offenses of that charged offense.
I don't have a problem with that. Are the people okay with that?
I mean, look, I went to college, I went to law school, I've been a lawyer for longer than I care to think about, and when I see the term both of those above number conditions, that makes me think of some contract drawn up by somebody in 1872, and I have a hard time figuring out what that is, and I've had a lot of legal training. So I think that the purpose of that next sentence and why the august body that came up with these jury instructions put this second sentence in there is, well, third sentence in that paragraph, is because they realized that that first sentence was somewhat confusing and they needed to explain it further.
I think that
And I'm just trying to make it less confusing. It just repeats the sentence before it in part.
Right, hold on. Yeah, Mr. Orman, I don't see that we would lose anything if we delete that last sentence and if we amend the penultimate sentence in the paragraph. And I know that you know the definition of penultimate, because you explained it to Mr. Brockler, so, but I don't think we lose anything if we make the change that Ms. Nelson is asking me to make and then delete the last sentence. The penultimate sentence would read, in order to meet this burden of proof, the prosecution must disprove beyond a reasonable doubt both of the above number conditions with respect to the act alleged in the charge offense in each count and in each of the lesser included offenses of that charge offense. So that's exactly what the next line says right now. So it's repetitive, and I don't think we need it. If we make the change that Ms. Nelson is suggesting.
Frankly, Your Honor, I think maybe we only need the anti-penultimate sentence in that paragraph. In other words, the first sentence. I've just learned this word in the course of this trial. Anti-penultimate is third to last.
Right.
And I taught it to Mr. Orman.
Oh, okay.
Because I just think this above number conditions language is dreadful. And it's really, now I'm looking at it, I think it's really hard for people to understand what that means, the above number conditions. That's like something out of a contract.
I don't think it's that confusing, and I would object to taking it out.
Yeah, I'm not comfortable taking it out. I don't think it's confusing. I mean, the only number conditions are the two. I mean, both of the above number conditions, those are the two. So I don't, I could say both of the above number conditions in this instruction or something, but I think it's pretty clear what it refers to. So I don't think I'll make the change that Ms. Nelson is asking me to make. I think that makes sense. But I don't want to take out that sentence. I think it's an important sentence, and I think the committee was trying to make sure the jury understood that the instruction is referring to where it says number 1 and number 2 in this instruction. So, all right. Anything else, Ms. Nelson?
Again, there's just a reference to Part A of the verdict form. So
Right.
I have an argument about that when we get there.
Okay. The next one is the phrasing capable of distinguishing right from wrong, and that instruction. Mr. Orman, anything in addition from you with respect to this instruction? I know you object to the word illegal instead of criminal, and you made a record about that at the last conference. The last the last instructions conference. I still don't see a whole lot of difference between the two, and I don't think it changes the meaning of what the Supreme Court was trying to convey. Anything in addition from you?
Nothing additional, Your Honor. Thank you.
Anything additional from you, Ms. Nelson?
Nothing additional to the arguments I made previously.
All right, the next one is the informational instruction, which again, every time I see it, I still find it odd, but, there's not a whole lot I can do. I'm bound by the Supreme Court's decisions, and I know why the Supreme Court asked us to give this instruction, but it is still a little bit of a strange instruction because we're telling the jury this is for information only, but we're giving it to you. And I don't know that there's any other, that there's a better solution, by the way. So I want to make clear that I'm not second guessing the Supreme Court. I think the Supreme Court saw this as the best solution possible, and frankly, I don't disagree with it. I can't come up with anything better, and I talked last time about the two competing and conflicting concerns that exist, and I think this was the middle ground that the court found, and I think it's as good a middle ground as anyone's going to be able to find. So, Mr. Orman, anything additional from you?
Completely agree with Your Honor's sentiments on this. It almost seems like an exercise in cognitive dissonance, but I don't know what else we can do either.
All right, Ms. Nelson, anything in addition from you?
Nothing additional, just incorporate all of our previous objections.
Okay, the next one is, this one is the instruction that talks about the verdict forms as they relate to the question on insanity. And it starts out with, if you find the defendant guilty of any charged offense or lesser included offense, you should disregard the remainder of this instruction as well as Part B of each of the verdict forms. If, however, you find the defendant not guilty of all the charged offenses and lesser included offenses, you should answer the following verdict question in Part B of the verdict form for each count, did you find the defendant not guilty solely based on the defense of insanity? Answer yes or no. And then it goes from there. So, and again, this is one where I had to deviate from the model instruction in order to avoid risking confusing the jury or misleading the jury in any way. And I believe that this instruction in general is consistent with the model instructions, but not identical to the model instruction. And I believe it's consistent with 16-8-105.5 subsection 3 by Leckie and Collins. All right, Mr. Orman, anything from you with respect to this instruction?
No, Your Honor, I understand the necessity for this instruction and the procedure that it discusses. The only suggestion I would make, I can see someone reading this and being a little confused by any, just because it's sort of in the middle of the sentence there. I might suggest underlining that or something to give that particular word any, and in the next sentence the word all, more significance. I think it might be easier to understand that way.
All right, Ms. Nelson, first of all, do you have any objection to that request? He's talking about underlining any where it says in the first sentence, if you find the defendant guilty of any charge offense, and then underlining the word all in the second sentence, which says, if, however, you find the defendant not guilty of all the charge offenses.
I have a comprehensive argument to make about these verdict forms, and I object to this instruction in its entirety based on my argument about the verdict forms. So
Okay.
should we wait and talk about that when we get to the verdict forms? We have a few more that we
Why don't
can
we do that?
breeze through pretty
Okay.
quickly, probably.
Well, is there anything else that you want to say with respect to this one?
I'll reserve argument until I get to the verdict forms.
Okay, I'll leave it on you then, leave it to you to come back to this one and remind me of it, okay? The next one I have is the instruction related to the sentence enhancer, which is, did the defendant use or possess and threaten the use of a deadly weapon? That question. So, any objection with respect to this one from the people?
No, Your Honor.
And again, this is one that I had to deviate from the language in the model instruction for some of the reasons that I stated before. And I was presented with a choice of either staying true to the model instructions and risking confusing and misleading the jury, or making some changes, deviating from the model instruction in the hopes of reducing any risk and frankly eliminating any risk of confusing or misleading the jury. And I'm comfortable that I've chosen the course of action that will eliminate any confusion or any potential to mislead the jury. Ms. Nelson, anything from you with respect to this particular instruction?
I do have one proposed change that's reflected in the, I didn't submit a specific instruction on the special interrogatory, but I did include it in our proposed verdict forms, and our submitted verdict forms reflects this request. My request would be that the court phrase this special interrogatory in terms of proof. It's the prosecution's burden to prove always, and so
What part of the instruction are you on?
where it says did the defendant use or possess and threaten the use of a deadly weapon? Answer yes or no. So my request would be to phrase it in terms of proven or not proven, and so the first sentence would say, did the prosecution prove that the defendant used or possessed and threatened the use of a deadly weapon? Answer proven or not proven, and make the change to the verdict form accordingly, and also change in the last paragraph where it states have the four-person mark yes, it should say have the four-person mark proven.
All right, Mr. Orman, any response to that?
Your Honor, the concept of burden of proof is included in this instruction. It's included in the sentence. Underneath the two numbers, the prosecution has the burden to prove each number condition beyond a reasonable doubt. So that is included in the instruction already. I think the instruction, the way it's written, is much more clear and easy to understand than what counsel recommended.
And I disagree, Your Honor. In fact, I think it's the opposite. I mean, I think that if you're saying that the prosecution has the burden of proving each number condition beyond a reasonable doubt, then it shouldn't be yes or no. It should be proven or not proven. It's similar to how we don't ask juries to come back finding a defendant guilty or innocent. It's either guilty or not guilty, and so it should reflect proven or not proven, because that's really the issue.
But this is a verdict question. This isn't the same as a charge. And I agree with Mr. Orman. I think this is plenty clear. Not only is the burden of proof included in the instruction, I've included it in the verdict form as well. Even though the model instruction didn't include it, I went and took the step to add it there, to repeat it there, to remind the jury that it's the prosecution that has the burden to prove the circumstance that this question asks about. So there's no need, in my view, to change it. And this is consistent, in terms of the instruction, it's consistent with the language and the structure in the model instruction. So the objection is overruled.
Your Honor-
Anything else, Ms. Nelson, with respect to this particular instruction?
I'm sorry, Your Honor, I just wanted to constitutionalize my objection. I'd make the objection under the 5th, 6th, 8th, and 14th Amendments to the United States Constitution, as well as Article 2, Section 16, 20, 23, and 25 of the Colorado Constitutions.
All right, the next one has to do with the questions the jury was allowed to submit for me to ask of witnesses throughout the trial, and this is the model instruction. Any objection, Mr. Orman?
We do not object.
Anything from you with respect to this one, Ms. Nelson?
No.
All right, the next one has to do with the foreperson being able to submit a question for the court if the jury has a question. It's the stock instruction. Anything from the people on this one, Mr. Orman?
Well, no, Your Honor, except I have a feeling, even though Your Honor's already told them this, the first question we'll be getting is, can we get a transcript of something? And it might be useful to cut that off at the pass and to say, if you ask for a transcript, you won't be able to get one.
I'm pretty sure I emphasized it, but it's been 3 months. Do you have a position on that request, Ms. Nelson?
I think we should address that issue if it comes up, but not preemptively.
Yeah, I'm going to stick with the model instruction. If it comes up, it comes up. Hopefully one of the 12 will remember me saying it. I said it, and I repeated it like 3 times. And I remember telling them that I was repeating it because we often get a question, can we get a copy of the transcript? So hopefully they'll remember it. All right, the next instruction is the final instruction. And again, I've deviated a little, or a lot actually, from the model instruction, but it's for the reasons that I've stated. In this case, I have multiple counts. I have lesser included offenses. I have the insanity defense. I have I have a sentence enhancer verdict question. And then, of course, with the insanity defense, we have a verdict question that relates to that as well. So you put it all together, and you have a bunch of stuff going on. And given that we have 165 counts and 5 different types of verdict forms, I wanted to be as detailed as I could, even at the risk of being somewhat repetitive, to make sure that the jury understood exactly how to read the verdict forms and how to answer the verdict forms, if you will, how to proceed in this case. Any objection from the people, Mr. Orman?
No, Your Honor.
Any objection from the defense? Ms. Nelson, do you want to talk about your record now?
Sure, yes.
Okay.
This might be the appropriate time to talk about the verdict forms and our objections to the verdict forms.
All right, go ahead.
So I'll start by saying I read the statute, I read Bilecki, I read Collins, so I understand the basis for the court structuring the verdict form the way that the court did. However, I believe the defense maintains that structuring the verdict form in this unnecessarily confusing fashion would violate due process and the heightened reliability that's required under the 8th Amendment and Article 2, Section 20 of the Colorado Constitution, given the issues in this case and given that this is a capital case in which a plea of not guilty by reason of insanity has been entered. My first concern, I have a couple of different concerns, 2 main concerns with the verdict forms. The first is the separation into Part A and Part B, and the special interrogatory inquiring about the not guilty finding being based solely on the a finding of the not guilty by reason of insanity. Our proposed verdict form, as I'm sure the court saw, breaks it down very simply. It gives the jury 3 choices: not guilty by reason of insanity, or guilty of either the charged offense or one of the lesser included offenses. I think that's totally compliant with the law, with the Constitution, and it clearly lays out for the jury that they essentially have 3 different options in terms of their verdict for each count. The way that the verdict form is currently structured, it doesn't make that clear to the jurors. The jurors know, obviously, that we've entered a plea of not guilty by reason of insanity in this case. I understand that. I also understand that they've been instructed on the affirmative defense of insanity within the court's instructions. But when they get to the verdict form, the first page of the verdict form just simply asks them for a verdict as of not guilty or guilty. And it doesn't mention anything about insanity at all. And furthermore, the instructions and the instruction that it tries to explain how to fill out this form also doesn't make any mention of, in filling out Part A, you should mark the form, not, check the box, not guilty, if you find the defendant not guilty for any reason, including that the prosecution hasn't established the element of insanity beyond a reasonable doubt. So I have a lot of concern about the way that the form is structured and the fact that this it's a problem. I think in some respects it's analogous to the issue in Beck versus Alabama. It's not made clear to the jury that they have this third option of not guilty by reason of insanity. I don't see any reason why we shouldn't make it abundantly clear to the jury that really a finding of not guilty and not guilty by reason of insanity just be separated out to make that very clear. And so we object to the way that the court has structured the verdict forms, as well as to the special interrogatory, as well as to the instructions on how to fill out the verdict forms. Our first proposal, so that's, well, I should say that's the first argument. And I should note that in another high-profile insanity case that happened a couple of years ago that Ms. Spengler was involved in the Bruco-Eastwood case, the court did the verdict forms the way that we proposed, laying them out separately, the not guilty option, not guilty by reason of insanity, and then the guilty. And I have copies of those verdict forms if the court would like to see them at any point. Second concern I have is with the interrogatory that states that the jury should only fill out this Part B, this interrogatory, if they have concluded, if they have found the defendant not guilty by reason of insanity on all, or not guilty on all counts, excuse me. This, and again, I understand the case law, but to me this is a directed verdict and it would violate Mr. Holmes' right to due process, and as well as the heightened reliability required by the Eighth Amendment and Article 2, Section 20 of the Colorado Constitution. I'm not convinced that this is a correct statement of the law, because I think at least conceivably he could be sent to the Department of Corrections to serve a sentence for the explosives count and then later committed on the NGRI counts. So to the extent that the rationale in Bilecki and the statute is that it's the only purpose for the special interrogatory is for the court to determine whether the defendant should be sent to the Department of Corrections or to the state hospital, I'm not concerned at all about this court's ability to determine where the defendant should be placed, certainly. But what I am concerned about is totally confusing the jury. It's not necessary at all, and it's more than not necessary. It's a violation of Mr. Holmes' rights to due process in this case. Have the jury fill out that Part B interrogatory, regardless of, for every count, regardless of how they, what verdict they render on each individual count. There's no harm in doing that. The court can certainly distinguish and take a look at the verdict forms and figure out, what the result should be in terms of where Mr. Holmes goes. But that's just not a compelling reason to structure the verdict forms in that way. In addition, I would request that at a minimum, the court amend the instructions to make it clear that if their verdict is not guilty of the charged offense and its lesser included offenses for any reason, including the prosecution's failure to prove sanity beyond a reasonable doubt, essentially at least mentioning insanity at some point during the instruction, telling them how to fill out the verdict form so that they understand that if they find him not guilty by reason of insanity, they should still sign the not guilty section of Part A of the verdict form. Without waiving our other objections, I think that would at least help make it a little clearer for the jury what they are to do if they have concluded that he is not guilty by reason of insanity. And I guess the last thing that I would add is just because this is a case in which the death penalty is being sought, it's going to withstand potentially years of appellate review. The Colorado Supreme Court is going to have to take an independent look at the propriety of any death sentence, and that's necessarily going to require an evaluation of the actual verdicts rendered. And so I think that the verdict forms need to be very clear on each count whether the jury has found him not guilty by reason of insanity or guilty. And I would make my objections under Mr. Holmes' right to due process, right to present a defense, his right to a fair and impartial jury, and his right to a fair and reliable sentencing proceeding as protected by the 5th, 6th, 8th, and 14th Amendments, as well as the Colorado Constitution in Article 2, Sections 16, 20, 23, and 25.
All right, Mr. Orman?
Stand up for this.
All right.
Your Honor, I'm not a big fan of this all or nothing thing for insanity, but that's the law of this state. It's all or nothing. There's no halfway either. That's just the way it is. He can't be insane on part of the counts. We can't have him guilty on some and insane on others. It just doesn't work that way. So these instructions and the verdict form that is presented by this court accurately reflects the law of this state and does it in a fashion that it is easy for the jury to understand. One thing I think is important to note is the court has expressed its plans, and I've never seen a judge not do this in all the trials I've ever done or seen, is that you're going to read these verdict forms to the jury. And the verdict forms in and of themselves are a type of instruction because the jurors see them and have them read to them while they're sitting in that jury box in the court. You, Your Honor, are reading them instructions. So they're going to have heard already, have read to them already Part B. So they will know. It's not like they're going to get back there and that'll be the first time they've seen these verdict forms and these interrogatories and get back there and have seen Part A and go, oh, gosh, where's insanity? I don't understand how this form is done. So it will be clear to them. They will understand. All the court's instructions are clear. These don't violate any rights of the defendant, and they accurately describe Colorado law and are in accordance with our law.
I thank you.
And Your Honor, that is absolutely not the law in the state of Colorado. The law in the state of Colorado is that the jury can find him not guilty by reason of insanity on any one count and guilty on any other count, that they have to consider each count separately. And in fact, there's another instruction that we went through earlier today that states exactly that. And I would cite the court to People versus Bilecki, in which it states that the defendant contended that there was a portion of the jury instruction in that case. It was a related issue to the special interrogatory form that stated, if the defendant is found guilty of one or more of the offenses charged, he cannot be found not guilty by reason of insanity as to any other offense charged. And the argument there was that amounted to a directed verdict on all counts as to the issue of sanity once the jury found him guilty of any charge. And the Court of Appeals, the Court of Appeals held that they agreed that the inclusion of that language was error. And so it is not the case, as I'm sure the court is aware, that it's an all or nothing proposition. That is not the state of the law in Colorado, and that's exactly what I'm worried about. If Mr. Orman has misunderstood the verdict forms in that way, then what is the jury going to think when they're presented with these forms? Because that's not the case. That's simply not the case. They can find him NJRI on any given count or guilty on any other given count. They have to consider each count separately, and that's why these forms are confusing.
I disagree that the verdict forms are confusing. I think they're really clear, and on some counts of not guilty by reason of insanity and then guilty on other counts. And that's the law in Colorado. That's, it's one thing to say, well, Judge, the law may be wrong. Well, that may be, but I can't disregard the Colorado Court of Appeals or the Colorado Supreme Court or the Colorado Legislature. In this case, there's authority from all three on this very point. I have the Colorado Legislature telling me this is how it's done. I have the Colorado Court of Appeals telling me this is how it's done. And I have the Colorado Supreme Court telling me this is how it's done. The defense of insanity with respect to each count separately and independently. And I tell the jury that. And that's why I emphasized the one instruction earlier that says exactly that. But in the end, we only care to know about the reason for a not guilty verdict if the jury finds the defendant not guilty of all the counts. Otherwise, we don't care. And that's the law in Colorado. The law in Colorado is, members of the jury, if you find the defendant guilty of even one count, then we don't care about the reason that you may find him not guilty of any other count. All we care about in terms of those other counts that you find the defendant not guilty of is that you're finding him not guilty. We don't care if it's because the prosecution failed to prove that the defendant was sane or if it's because the prosecution failed to prove any other element of that crime charged. We don't care and we don't want to know. That's the law in Colorado and that's what I have to follow. And this then avoids the situation where you have a guilty verdict, say for example, on the count of first-degree murder, and a not guilty by reason of insanity verdict, say for example on possession or control of incendiary devices. What is the court to do in that situation? Does the court send the defendant to the Colorado Mental Health Institute of Pueblo, or does the court proceed to a sentencing proceeding? And this is what the law, part of what the law wants to avoid and part of what the law avoids. And what the law says in Colorado is if he's found guilty of even one count, then we don't need to know as to the reason for any not guilty verdicts in the same case. All we need to know in that situation is that he was found not guilty of some other counts. And that's exactly what my verdict forms and the instructions as they have been drafted do. It is exactly consistent with Colorado law, and it does exactly what Colorado law says. I don't find the verdict forms confusing. I don't find the instructions confusing, and I don't believe the jury will find either confusing. The defense's verdict forms, Ms. Nelson asserted, are simpler or easier to understand. Well, this is not a contest for making it as simple as possible. The idea is I have to make them consistent with the law and then make them as simple as possible. I can't just say, I'm going to do it this way because this is the simplest way, or this is going to be the clearest way for the jury. Forget the law. It's going to be clear to the jury. Or it may be inconsistent with the law, but it's going to be clear to the jury. That doesn't work. And so to the extent that another case that Ms. Spengler may have been involved in did it that way, I'm not going to follow that case. First of all, I'm not bound by other trial court judges. And secondly, I'm bound by the Court of Appeals, the Supreme Court, and the legislature. So in terms of the verdict forms, in Part A, asking only about guilty or not guilty, that's exactly what the model instructions say we should do. And that's exactly what Colorado law says we should do. And so that's what I'm doing. I don't think there's anything wrong with that. And I think the jury will get it. In terms of the final instruction saying that the jury should complete Part A of the verdict forms if he finds the defendant not guilty, even if the only element that was not proven by the prosecution was sanity, to make it clear that includes the issue of insanity. I don't think that's necessary. I'll take another look at the verdict forms, but I don't see that as being something that's needed. I think that's only going to make the instructions more confusing, not less confusing. And that's not to say that I think there's any confusion in the instructions. I think they're clear, but I think that risks making them confusing as opposed to making them clearer. Let me see if there's anything else that I wrote down in my notes that I needed to respond to. The separation between Part A and Part B of each verdict form is exactly what Colorado law tells me to do and is consistent with the model instructions. And by the way, I will read all the instructions to the jury. I will read 5 sample verdict forms to the jury. I will go over all of that with the jury. In addition, counsel are free to go over all this with the jury as well. Counsel are going to have 2 hours to make closing arguments. They can discuss the instructions. They can explain the instructions to the jury to make sure the jury understands them correctly. There's absolutely nothing wrong with that, as long as they do it consistent with the instructions in the verdict forms in Colorado law. And so there's that as well, and I wanted to mention that. So the first, based on my comments, the first request to restructure the verdict forms is denied. The second request to have the jury fill out Part B of all the verdict forms just because it does no harm is denied. And the final request to at a minimum make it clear in the last instruction, the final instruction, that if the verdict is not guilty of a charged offense and lesser included offenses in account for any reason, including because the people didn't prove the issue of sanity or solely because the people didn't prove the issue of sanity, that the jury should still fill out Part A. Again, I don't think it's necessary. I'll take another look at it this weekend and make a final decision on that, but I don't see that as necessary. I think it's very clear as constituted. So that takes care, I think, of all the verdict forms, as well as the, I'm assuming, Ms. Nelson, that was the record you wanted to make with respect to the verdict forms or the reference. Let me back up. I'm assuming that's the record you wanted to make with respect to the verdict forms, with respect to the final instruction, and with respect to the instruction that follows the insanity instruction, as well as the references in any other instructions to Part A of the verdict forms. Is that correct?
Yes, so that's the basis for my objections to the, I'm sorry to repeat, but I just want to make sure the record's clear, to my objections with respect to all the elemental instructions, the references in all the elemental instructions as to Part A of the verdict form, similar references in all the lesser included instructions, similar references in the insanity instructions, as well as the final instruction. I also just wanted to add one additional requested change to that final instruction that I forgot to mention the first time around, Your Honor.
Yes, which one?
Which is just that, I think it's on the second page. If you find the defendant guilty of any charged offense or lesser included offense, you should disregard Part B of all the verdict forms. Just the paragraph that discusses in general Part B, my request would be to just explain what Part B is, that it's a special interrogatory on your basis for the not guilty verdict. Just give some kind of sentence or explanation that indicates what Part B is for.
Where is that again?
On page 2, it's the paragraph that starts, if you find the defendant guilty of any charged offense or lesser included offense, you should disregard Part B of all the verdict forms.
Okay, what do you want me to clarify? I'm sorry.
Just somewhere in that paragraph, perhaps after the first sentence, something along the lines of explaining that Part B is a special interrogatory to determine the basis for your not guilty verdict, or something like that, or something explaining that Part B has to do with insanity, something to call the jury's attention that they're not, by signing the not guilty section of Part A of the form leads them to Part B, where they specify the basis for their not guilty verdict, just so that they're given a little bit more of an explanation as to what Part B even is, if that makes sense.
All right, do the people have a position on that?
Would word that, it's not calling this an interrogatory.
Right.
I don't think many people other than lawyers know what an interrogatory is.
Well, and they're called verdict questions now under the model instructions for that reason.
Right.
I don't mean to get hung up on the word interrogatory. I'm fine with verdict question form, or a question form that is inquiring about the basis for your not guilty verdict or something like that, just to indicate that if they find him not guilty, then they'll go on to specify as to whether or not the basis for their not guilty verdict is because they're finding him not guilty by reason of insanity.
Well, by the time they get to that instruction, I will have given them the instruction that follows the insanity instruction, which tells them exactly what Part B of the verdict form deals with. That's the one that says that they have to answer, if they find the defendant not guilty, they have to answer the question in Part B of the verdict form for each count. Did you find the defendant not guilty solely based on the defense of insanity? So that, by the time we get to that last instruction, they will know that. And then we'll go through the verdict forms again. They'll figure that out at that point. So I don't think it's necessary.
And finally, Your Honor, and I just wanted to clarify this because I don't want anything that I said in perhaps an inartful way to be misconstrued for the record for an appellate court later, but our verdict forms that we propose to the court, the reason we propose them the way that we propose them is because we think that they're necessary to protect Mr. Holmes' constitutional rights, not because we simply think that they're easier to understand. That's, of course, the motivation behind it, but in the end, our argument is that in order to fully effectuate Mr. Holmes' constitutional rights to due process and a fair trial and a fair and reliable sentencing proceeding, the jury has to understand have a complete understanding of how the verdict forms work and what the effect of the verdict forms are. So I want to make sure the court understood and the record's clear that my basis for my arguments is the Constitution and not just, it does no harm or anything like that. It's that my requests, I believe, are constitutionally required.
I understand. And that's how I understood it before. But I also, as I said before, I am bound by the law. I don't have the authority to find that we have to do things differently than the way the legislature tells me to do them and the way the Supreme Court tells me to do them and the way the Colorado Court of Appeals tells me to do them. Even if I think on my own that this is the way that it's best to proceed or that it's appropriate to protect anyone's rights, I am bound by the law. I'm bound by the legislature, the law the legislature passes. I'm bound by the Supreme Court's opinions, and I'm bound by the Court of Appeals opinions. And I don't have the authority to disregard any of those three. Generally speaking, when the court is dealing with a difficult issue, there may be one authority, one out of those three. In this case, I have all three, and I can't disregard all that authority. There's a reason why the law is the way it is, and I understand the reason for it. I get it, and I don't think that not only do I not have the authority to do it, but even if I had the authority, in this case, I don't believe it's necessary to deviate from the law in order to protect the defendant's rights. The defendant's rights are protected even under the law the way it exists in Colorado. That includes his constitutional rights, his statutory rights. That includes all his rights. The law the way it is does not violate any of his rights and protects all of his rights. So, all right. Now, Ms. Nelson, do you want to, first of all, is there anything else in terms of the instructions and the verdict forms as they are constituted, anything else from the people that the people want to state?
So I don't forget, can I make a request about this, Your Honor?
Yes?
Is that when we get the final set of these instructions from the court, can we get another copy in Word, because it'll be easier to incorporate into slides if we
Yes.
do that. And also, I know the court said it wasn't posted on the website, but it didn't mention anything about these being suppressed or anything like that, and I can't think of a reason for that. When we get the final set, would the court have any problem with us sending the instructions to victims so they would have an opportunity to read along as the court reads?
Once they're final, you can send them to them,
Thank you.
to the victims, yeah. All right. Anything else with respect to the instructions and the verdict forms as constituted then, Mr. Orman?
Nothing, Your Honor. Thank you.
All right. Ms. Nelson, I know you have some tendered instructions, but before we get to that, anything else with respect to these instructions and verdict forms as constituted?
Not that I can think of at this time, Your Honor.
Okay, and again, as I've said before, I'm going to read all the instructions. I'm going to read 5 verdict forms. Those are the 5 sample verdict forms. I don't think it makes sense to read 165 verdict forms, or we'll be here till next month. So I'm going to read the 5 that are representative. There are 5 types of verdict forms, and I'm reading 1 of each type. So, all right, Ms. Nelson, so do you want to talk about your theory of defense instruction and perhaps the other 3 instructions that you want to tender?
I can do that, Your Honor. I do have copies for both the court and the prosecution.
And while she's doing that, Mr. Orman, the people don't have any instructions, additional instructions to tender.
We do not.
All right, Ms. Nelson, yes, you may approach.
Okay. Sorry, I have them separated out into 4 different piles, so it might just take me a minute to
Oh, take your time.
disassemble them. So, okay, here's one.
Hey, Kathy. Kathy.
May I approach?
You may. Thank you.
And to be honest, Your Honor, I'm a little bit at a loss about how to number these. I don't know if I need to number them. We didn't end up numbering the instructions that I submitted previously. We just referred to them by title. At this point, maybe that's just the easiest thing to do, is to refer to them by title.
Okay,
I
I think
think that-
so. I think that's what we did last time.
The instructions that I submitted before, I think, should have started with number 2, and I could go back and number them and then number these, but for the purposes of this hearing, I suppose we should just refer to them by their title,
Do you know?
if that's okay.
I'm sorry. Do you know, Ms. Gerlings, what the last number was? Two? Well, but the defense submitted some instructions. They filed some. Did they number those? No, right? Yeah. Since you didn't number the last set, I think there is one that's number
Right.
1, which was a tender instruction related, I think, to the model, the physical model of the theater, and that was tendered during the trial.
Right.
I don't think that you numbered the ones that you tendered before the first jury instructions conference. Since we stuck with the titles, why don't we just stick with the titles for this one too?
Okay, and what I could do,
You
if
could
it's
file,
necessary for record purposes, I suppose I could file a pleading at some point, just designating numbers once we get through these.
it's up to you. You filed the last set, I think at my request, and I can let you file this set the same way without numbering them, but with the titles. And I think I know we spoke about all the ones you tendered last time. We just referred to them by title. And these ones, for the record, are titled Theory of Defense, Duration of Insanity Immaterial. Actually, this one doesn't.
Oh, it doesn't have a title.
There's one that doesn't have a title. The next one is Impact of Psychotic Delusion, an Ability to Distinguish Right from Wrong. And then the last one doesn't have a title, but it's the only one without a title of all the ones that have been tendered. And it's titled Defendant's Proposed Jury Instruction Number Blank. And it reads as follows. You are instructed that following the conclusion of this trial, no juror is permitted to provide any person not involved in this case, including members of the media, with information about another juror, including another juror's name or contact information, or information concerning another juror's verdict and or comments during deliberation. So that's the last one. So do you want to, so I'll leave it up to you, Ms. Nelson. It's however you want to do it. I think the record is pretty clear as to what your instructions are. I think you should definitely file
these, yeah.
So why don't you file them, then there will be a record of them. I read them into the record in terms of title, and then I think your record is complete. But if you want to number them and refile them number, I'll let you do that as well, okay?
Okay, thank
All
you,
right.
Your Honor.
All
Which-
right, let's talk about these ones, see if we can talk about these ones. Since I just read that one, let's talk about that one. Do the people have a position on this one, the one that I just read? Any objection?
Well, just the fact that I think it would violate the jurors' First Amendment rights in perpetuity I don't think the court can do that. So the court instructed the jurors who, I believe, I recall the court saying, hey, don't give, when concern was expressed, if you're concerned about your identity being disclosed, don't tell the other jurors your identity. They don't have to tell the other jurors their names. And I don't think that this court has the power to say to the members of this jury, by the way, for the rest of your life, I'm enjoining you from speaking to anyone on these topics. I've never heard of a court doing that, and I don't think the court can do that. So I think that this instruction in all aspects would violate the constitutional rights of the jurors.
Ms. Nelson?
And Your Honor, the reason why we're requesting this instruction is because a number of prospective jurors raised issues concerning privacy and the media during voir dire, and so we know that that's a concern for at least some jurors. And in addition to the obviously high-profile nature of this case, there have been other instances, such as the Jodi Arias case in Arizona stands out, in which there was one holdout juror who was then outed by the other jurors and received death threats, and it was all over the media. And so we're simply trying to craft a way for the court to assure jurors that if they're free to speak to the media about their own verdict and about their own thoughts and feelings and opinions about the case after the case is concluded, but that they should respect the verdict of other jurors and should not be permitted to speak about what other jurors' deliberation processes were like, or what the vote of other jurors in the jury room were. And we think that this can also be just cleared up in the court's discharge instructions, that this doesn't apply to the parties or the attorneys or anyone involved in the case, that they're free to speak about their involvement in the case, their deliberations, and any other juror to the parties or the attorneys, but it simply applies to people who are not involved in the case. We would just make the request based on Mr. Holmes' right to due process into a fair and impartial jury, as well as the heightened reliability required by the Eighth Amendment, and I'd say to the Fifth, Sixth, Eighth, and 14th Amendments, as well as Colorado Constitution, Article 2, Section 16, 20, 23, and 25. This is to protect all of the jurors. It's not going to violate any rights.
Okay, I agree with Mr. Orman. I don't have the authority to tell the jurors to do this. And furthermore, I'm not aware of any case law or statute that allows for this instruction to be given, much less requires it. So I don't think it's an appropriate instruction, and so that tendered instruction is rejected. The next instruction is the one that's titled Duration of Insanity Immaterial, and it reads as follows: the duration of insanity is immaterial so long as the defendant was insane at the time of the alleged crime. And apparently this comes from People v. Voth, V-O-T-H, 312 Pacific 3rd, 144, Colorado, 2013. I may have read that case, but I haven't read it recently, much less with respect to this proposed instruction. Do the people have a position?
I think this case says that the court needs to give this instruction. I think this is a throwaway line in this case. And I think the court at the last instruction conference mentioned the precedent in Colorado that warns the court about just pulling language out of cases and putting that in instructions. This instruction is not necessary. Insanity is defined quite clearly by the court, and this instruction could actually be confusing to the extent that there's been lots of testimony from various mental health professionals about duration of illnesses, onset, prodromal, blah, blah, blah. And this almost, I understand insanity is different than mental illness, and that's pretty clear, but I think this could be construed by jurors to say, well, okay, the length of the mental illness isn't important. This is almost instructing a jury that they could find some kind of temporary insanity. In fact, I think that's sort of what it does. And there is no such thing as temporary insanity in Colorado, so I object to this instruction.
All right, Ms. Nelson, anything from you?
Well, Your Honor, I think that's essentially the holding of Voth, is the very proposition that Mr. Orman just disavowed. But this is not a throwaway line from this case. I mean, this is this is a correct statement of the law. And the reason we're requesting this instruction is because it's clear that it's an issue in this case. It's a correct statement of the law, and the jurors need to understand that this is part of Colorado law, and they need to understand so clearly in order to render an accurate and reliable verdict. We've had a lot of jury questions from the jury about posed to different psychiatric experts. When do you think that the defendant became insane, for example? And we've inferred from those questions that it's not clear to the jury necessarily that the only point at which it matters, a defendant's insanity matters, is the point at which at the time of the commission of the acts. And in addition, we've heard a lot of testimony from the court-appointed experts that the basis for their insanity, their finding that Mr. Holmes was sane, includes facts pertaining to events and issues in the months leading up to July 20th. So, the court-appointed experts, for example, I know relied upon in part the fact that the Google chat with Ms. Dada in March of 2012, in which Mr. Holmes describes killing other people as evil. That was a basis for their finding that he was sane on July 20th. They also found significant, his ambivalence about disclosing details about his homicidal thoughts to Drs. Fenton and Feinstein. Again, that was in the months leading up to July 20th. And they're relying on these events preceding the act itself to reach their conclusions about sanity. And so it's important for the jurors to understand very clearly that even if Mr. Holmes was sane in March, in April, in May, in June, in the early part of July, that if they find that at the point at which he stepped into that theater, he could not distinguish between right and wrong, then he is insane. And so it's the time of the commission of the acts, and that's the only time that matters under Colorado law. So it's an accurate statement of the law, and it's a very important issue in this case. And so we would request that the instruction be given and rely on Mr. Holmes' rights to due process, to present a defense to a fair and impartial jury, and to the heightened reliability required by the 5th, 6th, 8th, and 14th Amendments to the United States Constitution, as well as Article 2, Section 16, 20, 23, and 25 of the United States of the Colorado Constitutions.
Hey, Your Honor.
Yeah.
It's not dispositive. Sure, it's not dispositive when the quote-unquote insanity arose. Obviously, our position is it never did and never has. The defendant's own expert, their own handpicked expert, Dr. Woodcock, came in here and said the defendant was legally sane until July 8th. Then he became legally insane. That was what he said. We're talking about the allegations and assertions of some mental disorder that caused the defendant to lose the ability to distinguish between right and wrong. Well, as various experts have testified, these disorders are not something that arise in an instant, in a puff of smoke, that they take a while to develop, that they go through various phases, and that at some point, according to the defense experts, the defendant lost this ability. Well, if it's irrelevant, that means that pretty much all the testimony regarding insanity is irrelevant, that all we should have had is someone come in and say, in this particular second, in this particular moment of time, he was insane. Well, obviously, that would be a nonsense. And the jury has to consider the premeditation. The jury has to consider the events leading up to the crime, to determine under the totality of the circumstances whether they believe the defendant was insane when he committed the crimes. And this discussion, this instruction, would sort of tell them the opposite, that they don't need to consider that. The instructions that the court has already on insanity adequately and correctly inform the jury of the law.
I agree, and with Mr. Orman. I agree with Ms. Nelson that the law is that the people have to prove that the defendant was not insane at the time of the commission of the act. But that's going to be clear from the instructions. In fact, I think it's been made clear to the jury. This is a smart jury. They have revealed that through their questions. They're not stupid. And I think that the questions that they have submitted about when do you think the defendant became insane or when do you think the defendant became mentally ill are not a reflection of their misunderstanding of the law, but rather their attempt to question witnesses about their opinions, their attempt to try to figure out where the witness is coming from and what the witness is relying on. Similarly, opinions from experts about different time frames doesn't mean that the defendant was sane, has to be sane or insane at times other than the time of the alleged act. That just goes to whether he was sane or insane at the time of the alleged act. It's probative of that, and that's why it was admitted, and I think that's why, and that's how the jury understands it, and certainly that's how the instructions will read, that's how they do read, and that's how the jury will be told the law is in Colorado, and so it's unnecessary. I think I do remember VOTH, V-O-T-H. I think I do remember the discussion about the fact that although there is no temporary insanity defense in Colorado, in a way, it's sort of temporary because the only thing that's relevant is whether the defendant was sane or insane at the time of the commission of the act. That's what you're looking at. That's what the issue is. But it's an instruction that is not necessary. It's an instruction that I think has the potential to confuse the jury, and it is not an instruction that is in the model instructions or that the Colorado Supreme Court or the Colorado Court of Appeals tells me that I should instruct on, or that I should give the jury. So it is rejected. The last one we'll talk about before we take a break. We'll take a break so that everyone can take some time with the theory of defense instruction, but also because my court reporter needs a break. But the next instruction is titled Impact of Psychotic Delusion on Ability to Distinguish Right from Wrong, and it reads as follows. A defendant may be judged legally insane under Colorado law where his cognitive ability to distinguish right from wrong with respect to an act charged as a crime has been destroyed as a result of a psychotic delusion. And the authority cited is as follows: People versus Serravo, S-E-R-R-A-V-O, 823 Pacific 2nd, 128, Colorado Supreme Court, 1992, and People versus Galimanis, G-A-L-I-M-A-N-I-S, 944 Pacific 2nd, 626, Colorado Court of Appeals, 1997. What's the people's position on this one, Mr. Orman?
Your Honor, the definition of insanity is correctly set forth in the instructions that the court has presented. The definition of insanity, the things that we, as the prosecution, have to disprove beyond a reasonable doubt, are defined in language that has been passed by the legislature of this state and signed by the governor. This is language taken from a couple of precedents in Colorado. This is not what we have to prove. What we have to prove is outlined already in these instructions and in the statute. This would essentially give us an extra element to disprove that the defendant's cognitive ability to distinguish right from wrong with respect to an act charged as a crime has not been destroyed as a result of a psychotic delusion. In other words, we sort of have to disprove a psychotic delusion, which we don't, because that is not an element of insanity, that we would then have to prove this destroyed thing, which is not defined, which no expert has testified about, which no one has been asked a question about. It's extremely confusing. We don't have to prove it. It would be grossly improper of this court to give it, and we would object.
All right, Ms. Nelson, anything from you?
This is an accurate statement of the law. It is the law that delusions can render someone insane. And again, this issue is directly pertinent to this case. Mr. Holmes's delusions form a critical part of his psychopathology. And the question in this case, the essential question that the jury has to decide is what is the effect of these delusions and how did it affect his cognitive process? And this is law not only that applies directly to this case, but that the jury otherwise would not be aware of if they were not instructed specifically on it. Jurors must be fully informed about the law in order to reach a reliable verdict and a unanimous verdict. And so we would request that the court give the instruction pursuant to the 5th, 6th, 8th, and 14th Amendments to the United States Constitution, as well as Article 2, Sections 16, 20, 23, and 25 of the Colorado Constitution.
Well, as I said the other day, there are a lot of cases in Colorado. All of those cases constitute case law. That's part of the law, but we don't give it all to the jury, and it is improper to give it all to the jury. I think this is an unnecessary and improper instruction. It is confusing, and it's not part of the model instructions. There's no authority that says that the jury should be instructed on this instruction, and so for all those reasons, it is rejected. All right, let's go ahead and take a break, and then we'll continue with the last standard instruction, which is the theory of defense instruction, all right? The court will be in recess. Thank you.
Please rise.